Good afternoon and welcome to this session looking at continuing competence, where our aim is to help you meet our requirements. We had a great session on continuing competence at our conference earlier this month, so it's a pleasure to get an opportunity to rerun the sessions for you, our virtual audience. So the way it's going to work is that we're going to play a recorded segment of the key presentations, a segment that we recorded at the physical conference, and the recording will last just over 25 minutes. After that, we've reconvened our expert panel for this session, so they're here to take your questions. To submit a question, you should be able to see a link under the video. Simply type your question here. Don't be shy, and by all means start submitting your questions as soon as they come to you. Don't wait until the end. And then once the video has finished, we'll go to the panel to answer your questions. So I'm going to hand over to myself wearing a slightly different outfit, the outfit I was wearing at the conference a couple of weeks ago. See you shortly.
Before we kick off though, let's do some introductions. So firstly, I'm Julie Swan. I'm Director of Education and Training at the SRA. In a moment, I'm going to hand over to Richard Williams, who's my colleague in the Education and Training team, Policy Manager there, and Richard leads our work on continuing competence. But I'm also delighted to welcome two external speakers to this session. We have Michelle Rosen, who's partner and COLP with Brightstone Law, and Richard Bell from Hill Dickinson. As with all of the sessions, full biographies of all of our speakers are available on the conference app. So I'm now going to hand over to Richard Richard from the SRA to kick us off before I bring in Richard and Michelle for a wider discussion.
Okay. Good afternoon, everyone. I hope you enjoyed the lunch. I've got a few slides to sort of canter through, but I was thinking a lot about this session this morning, and I've been involved with the SRA's approach to continuing competence since we moved from the old regime of requiring 16 hours of continuing professional development to what we have now. And I was thinking about all of the venues and conferences and stages that I've been at to talk about that, and this is by far the biggest stage that I've discussed continuing competence at. And I think that's reassuring for us as a regulator, because I think it means that you, as COLPs and your firms, are really engaged in continuing competence and ongoing competence. But there's been a lot of talk about trust and confidence in the legal profession this morning, and I think it's also reassuring for the public and small businesses that were on this stage today, because I think one of the key factors from our research that Anna and Paul mentioned this morning is that what drives, or one of the factors that drives trust and confidence in the legal profession is solicitors maintaining their competence and carrying out learning and development. So that's some really kind of positive signs there. I'm going to spend the next sort of 10 minutes running through, I suppose, some of the challenges we see as a regulator in how firms and solicitors face in meeting our continuing competence requirements, what you can do as COLPs and firms to address some of those challenges, and where we might be going next with our thinking around continuing competence. So I am sure you are all acutely aware of our regulations applying to solicitors and firms in terms of ongoing competence. There is a very clear responsibility for individual solicitors to maintain their competence, and there is a very clear responsibility on firms to make sure that their staff and solicitors that they employ are competent. And really, those rules and regulations that you can see on the slide there are really grounded in kind of, I suppose, protecting the public. You know, solicitors who maintain their competence post-qualification and firms that have controls and processes in place to do that, are maybe viewed as less of a risk in terms of a lack of competence, but also, I suppose, kind of poor quality legal services. And I think you all should be aware that actually as a regulator, we don't prescribe the learning and development that solicitors need to do to meet those requirements, and we certainly don't prescribe those controls and systems that you need to have in place to meet your firm's requirements. So I think over the last sort of 2 to 3 years, we as a regulator have really strengthened how we monitor if solicitors and firms are meeting their regulatory obligations around continuing competence. A few examples of that: we now analyse very regularly a whole massive data set that comes from us from lots of different reports made to us, other organisations, to really identify and understand potential competence risks and challenges. We carry out training record reviews and thematic inspections to understand if solicitors are carrying out learning and development and firms have those controls and systems in place. We also have introduced a new approach relatively recently where we will engage with a solicitor or a firm where we receive a report that doesn't meet our threshold for formal enforcement action, but where we have a competence concern. And in doing so, we'll engage with solicitors and firms within that firm to make sure that we, as a regulator, have assurances that they are meeting those obligations. And I'm sure for you that were involved in the last PCRE exercise, renewing practicing certificates, you will have noticed we have significantly strengthened our annual declaration. And what we know from all of this work is actually lots of solicitors and lots of firms are meeting those obligations. They have really good approaches and systems to maintaining competence. But what we do know is that some are also failing to meet those regulatory obligations. And I just wanted to unpick some of the challenges that we see firms and solicitors face. So we've identified through our work that there are actually some fee earners, some senior solicitors, and some CULPs who are genuinely not aware there is a regulatory requirement on individuals and firms to maintain their competence. We've also identified a lot of individuals at senior positions who may be aware that there is a requirement to maintain their competence, but feel because of their seniority or because of their post-qualification years experience, they don't need to maintain their competence. A lot of our approach is grounded in the concept of reflection. The solicitors must reflect on their practice, identify and address learning and development needs. And that's one way in which they can meet their obligation. And we saw lots of challenges in our work about how solicitors sometimes don't quite understand what that means in practice, or if they do understand, there are some challenges in terms of how they can incorporate that into their day-to-day work, given, I suppose, the work and the time pressures on solicitors. A third challenge that we found from our work is around a lack of awareness and application of SRA principles, guidance and warning notices. Our rules require that solicitors must act with integrity, with honesty, and in accordance with legal and regulatory obligations. And to do this, and to do it well, a solicitor needs to be aware of our warning notices, our guidance, and professional kind of obligations and requirements that apply to their role. And again, we found some really good examples of how solicitors and firms make sure that they are up to date with some of those warning notices and guidance. And you'll hear from our panelists about some practical ways in which they do that within their own firms. But again, we also found examples of where some solicitors were not aware and some firms did not have processes in place. We also found a failure of some solicitors to provide evidence. Now, it's not a regulatory requirement for solicitors to record their learning and development, but to us, if they do, it demonstrates that they are taking all of the appropriate steps in order to meet their regulatory requirements. And again, we found that by and large, most people keep a record of their learning and development or some other form of evidence, but there is massive disparities in terms of, I suppose, kind of the quality and the extent of that information that's included. By and large, what we see when we do our training record reviews is that the evidence that individuals are keeping are just lists of learning activity that they've undertaken. There is no evidence to suggest that they thought about their practice or that these are all of the learning and development needs that have been identified and addressed. And we also found through that analysis of training records that, again, going back to my previous point, there was sort of very little focus on sort of ethical ethical competence and upholding professional obligations. And that kind of takes me on to the final, I suppose, challenge that we see in terms of solicitors and firms meeting those obligations from the previous slides. And that is, by and large, as I've said, lots of solicitors are doing lots of learning and development, but that tends to be concentrated on maintaining technical practice. You know, those that are aware of our statement of solicitor competence will know that it covers all of the skills, knowledge and behaviours required for a solicitor to perform competently at the point of qualification and throughout their careers. And, you know, what we have seen is actually, you know, as I've said, there's a concentration of activity just on maintaining technical legal practice and less so on those other aspects of the statement of solicitor competence which may contribute to a solicitor performing their role competently. So I think the reason why I wanted to draw all that out really is to give you a sense of some of the challenges that we see, and for you as COLPs to take them back to your firms and your learning and development development teams and work out whether or not they present a challenge for your solicitors and your firm meeting our requirements. Some practical steps, and again, I won't go into too much detail because we have two excellent panelists to talk through that. But what can you do as a COLP to help make sure you're addressing some of these challenges? I think there's a number of ways. One, you can really think about whether or not there is, I suppose, a culture of reflection in your organisation. Are solicitors really thinking about their learning and development? If so, how are they doing it? Can that be improved? Lots of resources on our website to help you understand and help your solicitors understand reflection. I think you can also make sure that solicitors are recording their learning and development. You know, we come across lots of people who tell us they've done learning and development but fail to provide us with any evidence. So are your solicitors recording their learning and development? And again, it's worth thinking about how you can encourage through your systems and processes, solicitors to think about learning development, that it goes beyond just maintaining technical legal practice. And you can also think about how you, as COLPs, can make sure that your solicitors are aware of any warning notices, guidance, or any other regulatory information that we put out into the public domain that might relate to solicitors meeting their regulatory obligations. And finally, it's worth thinking through whether or not you're completely happy that your firm has in place effective supervision arrangements. So lots of detail, lots of kind of high-level questions for you to think about there and kind of ponder over when you take it back to your firm. As I said, we've really ramped up our activity in this area over the last 2 or 3 years. Part of that is publishing every year an annual assessment of competence. What that annual assessment of competence does is really provide an overview of the things that we're seeing in relation to ongoing competence. If you haven't read 2023's report or 2024's report, I'd really strongly encourage you to do so. There's lots of detail about some of the things that we're seeing there and our expectations in there. So I think as a COLP, it's really important you get that on your reading list and kind of disseminate that amongst your organisations where possible. But in each report, we outline the actions we're going to take in order to address the challenges we've identified. So over the next 12 months, I just wanted to give you an indication of what that work for us might look like. We will focus our thematic inspections and our training record reviews on family and landlord and tenant law. Now, the reason why we've selected those areas of practice is because our data and our intelligence is showing that actually over the last 12 months, there has been quite a noticeable increase in the number of reports made to us about those practice areas. Now, they are just reports. You know, not every report means that a solicitor is not acting competently or there's a problem with the firm. But it does indicate there is something there for us to look at, and those thematic inspections and training records give us an avenue to explore that in more detail. So if you're practicing those areas, you may well be called in to provide some evidence or have a visit from the SRA coming your way. We'll continue to develop our continuing competence resources. We've developed those quite significantly over the last 12 months. And as I mentioned, lots of information there about how you can record and lots of templates to help prioritise reflection and learning and development. We'll also engage with firms where we receive competence reports that don't meet our threshold for enforcement. So an awful lot of work we're doing to monitor whether or not you're meeting your obligations or not. Finally, I just wanted to talk a little bit about where we are going as an organisation with our thinking around continuing competence. That evidence that I've talked about and those kind of common and consistent themes that we're seeing presents to us a possible public protection risk. It means that some solicitors may not be maintaining their competence and there is the potential for consumer detriment. So that risk and the evidence now suggests to us that it's really time for us to think about whether or not our existing continuing competence requirements are fit for purpose and offer the protections that we're looking for as a regulator. So over the next 12 months, we're going to review our existing requirements. We're at the very early stages of our review. We haven't formed any final policy positions yet, but we are looking long and hard at our existing arrangements. And you can see sort of 3 questions there on stage in terms of what we're looking at. We'll be looking at how we can secure better engagement with our materials, with our warning notices, with our guidance. How can we drive better reflection and recording? We'll be looking at whether or not there's more we can do to encourage compliance from a regulatory framework perspective. But I think more fundamentally, we'll be looking at whether or not we should really strengthen our existing requirements and whether or not we should be prescribing what learning and development the solicitor needs to do, whether that's hours or topics, or whether they need to be undertaking learning and development against all aspects of the statement of solicitor competence. And we'll want to engage with you as we develop our thinking. If we think that any changes are needed to our existing requirements, we will consult in 2025. So hopefully that gives you kind of a whistle-stop tour of kind of what we're seeing and where we're going. As Julie mentioned, we've got colleagues on the stand in the marketplace if you have any particular questions about how any of this might relate to your own firm. But I think that's it for me, Julie.
Thank you, Richard. Do come back and join us. So Richard has highlighted some of the challenges that we've uncovered within the profession in terms of meeting continuing competence requirements. So the focus of the rest of the session is going to be, so what can we do to help people through those challenges? And we'll be drawing in particular on Michelle and Richard's experience of doing just that. So I've got some questions to put to the panel and a reminder to you to be thinking about questions that you would like to raise as well. So the first question, I'm going to ask Michelle to come in first, is to do with looking beyond technical expertise, acting ethically, honestly and with integrity in accordance with legal and regulatory requirements is core to being a solicitor. So how can this be hardwired into learning and development?
Well, just to build on what you just said, the starting point is, what does ethics mean? It means the moral principles that govern a person's behaviour or the conducting of an activity. Ethics are critical and they're core to being a solicitor. It's not only knowing what we're required to act ethically in accordance with the SRA principles and requirements, but doing so should and must underpin everything that we do. I believe that it has to be at the very heart of everything that we do, sort of part of a solicitor's DNA. At my firm, the subject of ethics, its meaning, is addressed right at the start of a staff member's journey at the firm, the induction. So staff know right from the very outset what the requirements are, including the SRA requirements, how that we as a firm embed them into the culture of the firm and what is expected. An example of what I do at Brightstone is I send weekly all-staff emails covering different topics such as AML, data, and what I will also do is some weeks send emails about SDT decisions where solicitors trainees have been disciplined when found not to have acted honestly or with integrity. My intentions are good and bad by doing that. It's always beneficial to show fee earners what happens when a lawyer does not act ethically, but also I like to place the fear of God into them. I see that as all part of the learning.
Thanks, Michelle. And Richard, how do you approach this in your firm?
So I think there are two things that are really important here. So the first thing relates to learning and development and what it actually is and what's encompassed in that. And the second thing is about the culture that you have present within your firms in relation to learning and development. So I suppose ultimately, when you speak about learning and development, a lot of people will make an instant association that it is about going and sitting in a room for a couple of hours and listening to somebody talk about a particular topic or subject, you know, whether that be ethics or anything else. But actually, I suppose what's really important with L&D is recognising that we have day-to-day opportunities to develop ourselves, and there are many opportunities that present themselves when our fee earners are working on different client matters and working with each other internally as well. And I suppose some of the things that lend themselves to, I suppose, hardwiring ethics into them are things like formal or informal mentoring relationships, where ethics becomes a feature of that relationship, and even informal professional discussions between colleagues as well. So making a point of building ethics into those discussions. Of course, there's always the old egg of refresher learning around code of conduct and requirements as well in relation to ethics, and I'm sure that many people in the audience are familiar with that and go through some kind of cycle of refresher learning with people in the firms. But I suppose if you are going to engage in any kind of formal sit-down learning activities as well, it's thinking about how can we make this real. So Michelle touched on making things real for people there as well, just in terms of some of those examples, but also some scenario-based kind of ways of working with people that get them to really think about some of the implications around ethics is really important. But I suppose to enable any of that to happen, learning has got to be treated really seriously, and that is really embedded in the culture of the firm. And I suppose at Hill Dickinson, what we have that really helps us is we have a very, very clear set of values and competencies which speaks to the ethics in the profession. So two of our values, trust and respect, we link a lot of our learning and development activity to those values. So whether that's people working with clients, whether that's people working internally or with third parties, it doesn't really matter. And again, the competencies, so they speak to the principles that solicitors have to work to, and that I think is also really, really important. And I suppose probably my final point on this is that whatever you put focus on, whether it's ethics or anything else, is generally what happens and what people take action on. So previously I've worked at a top-tier COMA site, control of major accident hazards. It was an oil refinery. And one of the things that was absolutely paramount there, in fact the paramount thing, was safety. So our Chief Operating Officer talked a lot about safety, and one of the things that sticks with me from my time there is I've heard him say on numerous occasions, if we cannot run this facility safely, we might as well go home and close the doors. So I suppose ultimately what happens over time, if these messages are repeated and we are making, in this case, ethics a really important feature of what we do, then that is what sticks and that is what people remember and that is what people consider before they act. So it's really, really important to keep the focus on that through L&D as well.
Thank you. So ethics front and centre.
Absolutely.
Thank you. Richard's mentioned the rich source of materials that's on the SRA website, but some of our findings suggest that not everybody's aware of them, or even if they are, not using them as they might. Can I come back to you again, Michelle? What do you do to help people engage with our resources?
Well, I think a good starting point is to actually tell staff what resources there are available. So what I did a few weeks ago is I sent staff an email and I said, this is the link to the SRA website, this is the link to SRA on LinkedIn and their Facebook page, so that they have the links to the SRA easily accessible. In addition, when the SRA publish new videos, warning notices and guidance, what I'll do is I will roll that out to staff in the hope that they will then read what I'm sending. But the point is it's making it easily accessible. It means that a staff member, you know, they are very busy doing their fee earning. So I want to make, you know, if they're going to be able to or I'm going to try and encourage them to look at the resources that you offer, that I make it accessible. I mentioned before that I send a weekly all-staff email. So by way of example, recently when I updated the firm-wide risk assessment, I did that in line with the the emerging risks that were identified in the SRA sectorial risk assessment. So at the same time as attaching the firm-wide risk assessment, I included in the email the link to this sectorial risk assessment, so that way it encourages staff, if they want to, having hopefully read through the firm-wide risk assessment, also having the link. So I find that very useful.
Thanks, Michelle. Richard, can you add to that in terms of your practice?
So a lot that is very similar to what Michelle has described there, and I suppose where I would like to start with this is a very scary statistic, and that very scary statistic is that we receive more information in one day than the average Victorian received in their entire lifetime, allegedly. And you can imagine it with all the different channels that are available for people to, I suppose, for want of a better description, bombard us. Yeah. So it is really, really difficult and tricky, I think, sometimes to work out what's important. So how we make this easy for fee earners is very, very important. And some of the things that we do, so appraisal processes, for example, we will put direct live links into documentation systems that people can literally just click on as part of that process to be able to refresh themselves on information. In terms of some of the wider guidance, policy guidance updates and warning notices, things like subscribing new starters to bulletins and updates. If you are in the luxurious position of having a knowledge management team at your firm, if you're of that size, then getting them involved in that in terms of distilling some of those messages and targeting them at different practice groups who they're relevant to is a really important piece as well. But I suppose ultimately, people need to know where to find this information. So one of the challenges is not having it scattered to the four ends of the earth and having a consistent place that people know that if they visit that particular, I don't know, intranet page or a particular folder on a shared drive, that all the information that they need will be there. And that, I think, is really important. But also what's important is that people at the top of your organisation, the senior people in your firm, are behaving in a way that makes this important as well, because again, if that importance is put on keeping up to date with policy guidance and warning notices, then that really, really helps people again to form some of those habits around making that part of their practice.
Well, welcome back, everybody. Welcome back to our virtual audience this afternoon. You'll see that I've magically been joined by our expert panel from the conference from a couple of weeks ago. A reminder, please to submit your questions using the link under the video. And thanks to everybody who has already submitted a question. We're very grateful to you. Don't be shy. The first question we've had, I'm going to put to Richard W., who you know well if you've been watching the video. And Richard, we've had a question about what we at the SRA do to monitor the declarations we get through. Do we check that those declarations are true?
It's a really good question, and I think the first part of my answer is that this is an important regulatory declaration. So in making that declaration, we expect any solicitor to be acting in accordance with their wider code of conduct obligations, so that they need to make that declaration kind of honestly and with integrity. But we have a whole range of tools and approaches if a solicitor is not maintaining their competence or not meeting their continuing competence obligations. So, for example, we'll do spot checks of training records in particular practice areas. As part of our thematic work, we do go out and look at training records. We'll also look at the systems within a firm that they have in order to make sure that their solicitors are maintaining their competence. And we also look at the declarations made when an individual identifies makes their selection as part of the PCRE. And if we have any questions, we will follow up on them. So lots of different approaches, lots of different ways we identified it. And if we do find through that work or our wider work, looking at reports that come into us, that actually there is perhaps a disconnect, or there is evidence between what someone put at the declaration at PCRE and what we're seeing on the ground, then obviously that's quite a serious issue for us, and we'll take action in line with our competence topic guide.
Thanks, Richard. And a follow-up question for you. And you've mentioned training records a couple of times in your response just then, and you mentioned training records at the conference a couple of weeks ago. And the question is why we don't require, as part of our rules, that solicitors have a record of the learning and development that they've undertaken.
Yeah, I mean, I think for the answer to that, we have to kind of go back to I suppose why we introduced our current approach to continuing competence, and it was very much grounded in giving freedom and flexibility for firms to determine their approaches to how they meet our continuing competence requirements. So it was a move really away from the prescription of the previous regime of 16 hours, and more towards, well, you know, you already have systems and processes in place, so use those to demonstrate that your solicitors are meeting our continuing competence requirements. But I think as I discussed in my sort of 10 minutes or so when I was talking on the stage, we're seeing quite a lot of evidence to suggest that actually, well, two things. One, solicitors aren't keeping a record, and secondly, where they do keep a record, there's variable quality in what's been recorded, and I think where that takes us to is to for us as a regulator to think very long and hard about whether or not we begin to prescribe or have a requirement that every single solicitor needs to keep evidence of their learning and development. And the reason why that's important, because that evidence, that record, demonstrates to us that individual is taking steps to keep their knowledge and skills up to date.
Thanks, Richard. So watch this space on potential changes to our requirements on record keeping. Michelle, can I bring you in? What's your expectation within your firm about how your solicitors keep a record of what they've done?
I think I mentioned it when I spoke at the conference, but we retain the same training period that was from many years ago when you had to try, I think if you work full-time or were a full-time solicitor, you had to acquire 16 CPD hours, and the year ran from the 1st of November to 31st of October. So we run the same period. And what I do is I send a copy of the firm's competency statement alongside an updated training record that sets out the requirements. And in addition, you know, the fee earners are encouraged to complete that training record. And when I send out training, for example, the Property Litigation Department got a webinar about Section 21 notices. So I sent the webinar around, and then I will I always say at the end of my emails, make sure that you record it in your training records, because I think whilst it's not, I don't see any other way of otherwise being able to record what you've actually done. And I think it also assists because you can then reflect on what you have done, like visually, and at the same time look and reflect of what you need to do, and sort of it's almost doing then being able to do like a gap analysis, I think. So at my firm, it is mandatory that fee earners keep a record, and then what I do is I check those on a quarterly basis, because that way that allows me to see what again what needs to be done, what hasn't been done, etc.
Thanks, Michelle. And how about in your firm, Richard B?
So we, I think, are quite similar, and I'm hearing some themes that Michelle and Richard are both talking about there that are very similar and recur in our firm. I suppose for us, one of the things that is really important is our annual and mid-year review processes, because they give an opportunity for people to not only plan their learning, but also to reflect on where they are at full annual review, and also I suppose what that gives us is it gives us an auditable trail of what people say they're going to do. In terms of recording as well, we are very fortunate, being a slightly larger firm, that we have a really good learning management system, which allows us to hold records centrally. And that solves quite a lot of the problem, I think, just in terms of being able to show engagement with learning. Appreciate that's not as easy for everybody. I think probably what Michelle is saying there for smaller firms is probably a really sensible approach in terms of making sure that we're encouraging and keeping the focus on continuing competence and the need to be able to evidence that. I suppose just to finish with on this, my own belief with this is that there is a 70%, 30% split in terms of responsibility. 70% of this should be on the individual fee earners, and 30% is about the firm and providing systems and mechanisms to make sure that the training is being recorded.
Thanks, Richard. And can I stick with you, Richard? We've had a question about reflection, and we know, and other Richard mentioned from what we see in some of the training records that we call in, that reflection is done to varying degrees, or certainly recorded to varying degrees in the training records that we see. And the person who's put the question in suggests that reflection and the requirements to reflect can be confusing, not least because a solicitor doesn't necessarily know what they don't know. How do you encourage solicitors within your firm to reflect, and how do you help them understand the importance of doing so?
So there are many things that I think as human beings reflect on a day-to-day basis. So I suppose, again, it's helping our fee earners really to recognise where they are reflecting. So even the act of preparing for one-to-ones and appraisals is reflection in itself. We do have a very simple evaluation process as well for centrally run learning, which asks our fee earners to essentially evaluate their learning, the behaviour and the results from that learning at 3 different intervals, and that is really effective as a way of reflecting on the impact of that learning. There is lots of other things that we can do as well, I think, and that's things like where we are running compliance training is to make sure that we have some kind of reflective assessment attached to that as well, which encourages people to really think about what they are watching, particularly if it's e-learning based, because that sometimes I think can be problematic when we are so, I suppose, strapped for time to get people to really focus on that. So the assessment is really important as part of reflection. There are other things as well. So just being part of groups and discussions is often very effective in terms of reflection. It doesn't have to cost a lot of money. It could just be peers coming together and asking each other a little bit about what they thought in terms of certain matters. So it might be things like lesson learned reviews, for example, that may also be helpful. But it's the nature of the questions we ask, and asking reflective questions to people is really important. So what have you learned? What are your next steps? What else could we do here? It's all those sorts of questions that, if we get into the habit of asking those of each other, really help us to think and reflect. So it's almost like a coaching approach in effect when we're working with people to prompt that reflection. And one more thing, just before I do finish, ask for feedback. So from people who you trust and you value, ask them for feedback, because that's one sure way to help us to really think about what we're doing.
Could I just say one thing, and I just to really reiterate what I said at the conference, that for any of those that would like some good guidance on a training record and the format, I found the SRA's template very good. It's on the website. It was, you know, we had our own. My firm had its own training record, but what I did was I amalgamated what we had with a lot of what was in the SRA. So I would encourage anyone today to go away and have a look and see if that would assist.
Thanks, Michelle. Thanks for that plug. And Richard W might want to give a bit of a plug to some of our materials on reflection as well.
Yeah, I think just building on some of the really helpful tips that Richard and Michelle have mentioned, I think just to call out, we do have resources on our website which will help you understand reflection, but also how you can apply it, but also kind of maybe prioritize some of the learning development needs. And then just in response to the question about, well, you know, how do I identify things that I don't know about? Well, a really good and quick and simple starting point is to have a look at our statement of solicitor competence, because that statement of solicitor competence outlines what we expect out of a solicitor, not just at the point of qualification, but throughout their careers. So you can have a look at that and have a look through and just go, actually, is there anything on here that I'm not sure I have the skills or knowledge about, and use that to reflect and drive your learning and development. And then the final plug would be for actually some kind of practice specific kind of resources we have. So for kind of practicing in the higher courts, practicing in the youth courts, for example, we have outlined what we think good practice looks like. And again, they give you more of a contextualized statement of solicitor competence if you are practicing in those areas.
Thanks, Richard. And before we move on, we've had a question about guidance. You mentioned, and as participants will know, that we've changed the declaration to include explicit reference to ethical obligations. And we've had a question about whether we plan to put out any further guidance to help solicitors when they're considering making that declaration.
Yeah. We are absolutely, and we will do so on the basis that we recognise that actually understanding kind of ethical competence and understanding what solicitors need to do in order to meet our obligations and their professional obligations can be difficult to understand, also difficult to find our information. So by summer next year, we'll produce some good practice examples of how solicitors and firms understand and apply our guidance and warning notices relevant to upholding their professional obligations. So again, those kind of documents and that kind of good practice and case studies will help bring alive how a solicitor can kind of maintain their ethical competence more broadly.
Thanks, Richard. And Richard B, you mentioned the division of responsibility, the 70-30 split, and we've been asked by somebody in the audience for a little bit more clarification about what you mean and how that works.
Okay, so I suppose 70% essentially being on the fee earner is very much about the responsibility for driving our own learning and development, and that I think is the first and foremost message with this. And the 30%, I think, essentially is really about the systems and the mechanisms that sit behind that the firm may provide to make this as easy as possible for people to engage with, because I suppose that's often the difficult bit when we're in a really time-starved, pressurized environment. It's often not a priority to go and look for some of those learning and development opportunities and materials. So I suppose ultimately with that 30%, it is essentially us providing that curation, pointing out resources, enabling people to participate in learning activities, but the 70% is really, I suppose, in terms of individual needs, really about people identifying needs that they know they need to meet. They may be technical, they may be non-technical, they may be related to the code of conduct, but everybody's different, and I suppose that's the challenge, isn't it, that we all have different development needs. So that driving those own development needs for ourselves is really important. And I suppose that could be, it doesn't really matter what the percentage is. I suppose the message is that individuals are responsible for their own lifelong learning with some support from the organisation.
Thanks, Richard. And I think we can draw on some of your answer to a previous question as well, your suggestions about asking questions, offering feedback, sort of those coaching questions as well, I think probably comes into that 30% too. We've had some questions in about firms' expectations beyond solicitors, how about support staff, and also how about consultants who might be working within the firm. I don't know, Richard, B. Michelle, would either of you like to pick up on that one?
I'm happy to start, and then Richard.
Thanks, Michelle.
We do a equivalent of a training record for our support staff as well, because I think it's essential that way, again, we can record their learning, record any training requirements. So, for example, we identified a couple of years ago that during the appraisals that staff wanted training on Excel, for example. So we arranged it. So the staff that attended, the support staff, there were a few solicitors, I think, but the support staff then, yeah, they have to record it in a training record. And likewise, when it comes to appraisals, that way we can identify if, because their roles are key. And I think it's very important that we can identify learning needs for those staff too. So we do, it's not obviously not exactly the same as the training record for fee earners, but it will record what training they've done, etc. So yes, we do roll it out to support staff, but in a different format.
Thanks, Michelle. Richard W., do you want to say a quick word about our regulatory expectations in terms of the wider makeup of the firm?
Yeah, I think it's just to obviously point out that, solicitors in their code of conduct have an individual responsibility to maintain their competence and keep their skills and knowledge up to date. But also in the code of conduct for firms, there is an obligation on the firm that they ensure that kind of managers and employees are competent to carry out their work also. So I think, as I mentioned at the very beginning of this Q&A session, we do look when we go out as part of our thematic reviews at the kind of processes and systems firms might have in place to ensure competence across all individuals that they employ.
Thanks, Richard. Is there anything you'd like to add, Richard B?
I think probably we don't really differentiate. I think in terms of our process, we have different competencies for fee earners and for non-fee earners in terms of expectation, but in terms of process, the process is exactly the same for both. We expect people to be completing career development plans, which helps them to think about where they are and where they need to be, and we also expect people to plan and then participate in the learning that they need to stay as a bare minimum competent in the role that they do.
Thank you. Now we're really keen that our expert panel are able to share some practical tips. Michelle, we weren't able to play the whole of the session in the video, but I know at the end of the conference you gave your top tips to the live audience, and I wonder if you'd like to share those with our virtual audience today, please.
Absolutely. I think it's fair to say that there are certain aspects of training that can be dull, but my opinion is that the training that you offer, that it's relatable and engaging. I gave an example where a lawyer, I think it was this year, went to a Harvester restaurant and didn't pay the bill. I think she said she was going to go back at a later date. I think left her passport in the restaurant and didn't go back. And then a few months later ordered food via Just Eat. And when the driver arrived, said that she paid for it when she hadn't. The point is she was struck off. And I do, as I mentioned during the session in Birmingham, I do weekly training emails to all staff that will cover all aspects of compliance, but I will also, so for example, in that I reported about that case. So it makes it, it's just making it interesting, because I hope then that the lawyers will be encouraged to read what I send on a weekly basis. But I think, that would be my one tip, to make it engaging, relatable. There's lots of things going on in the profession across the board, and I think communicate that to your staff in a relatable, engaging way as much as possible. So that would be my one takeaway.
Thanks, Michelle. Get their attention.
Yes, absolutely.
Thank you. And Richard B., any tips that you'd like to share?
I think a lot of this is around habit, so reflection, learning. They're both habits, and I suppose having the systems and having the mechanisms in place to perpetuate those habits and remaining disciplined around them is really important. So that's a good starting point, I think, is having systems and processes, but then really encouraging people to form the habits routinely.
Thank you. Good practical advice. Form those habits and keep them going and engage. Okay, I can't see any more questions coming in from our audience this afternoon, so I'm going to start to wrap up. But if there's anybody out there that's just got one more to post, I'll go slowly. So please post that question if you want to. But just in case nothing else comes in, I want to let you know that alongside the recording of this video, you'll find links to a range of useful materials on the subject, Richard's presentation, and we've already given a plug to some of the continuing competence guidance that we've got out there. We'd really like to hear your feedback. How could sessions of this type, or indeed if we were to run a session on continuing competence next year, be improved? It'll only take you a minute to share your feedback. This is the second day of our virtual compliance conference. We've got other webinars you'll be able to join throughout the week. Tomorrow, for example, there are sessions on your compliance queries, the accounts rules, and on our consultation on client money. So do look out for those. I can't see any more questions, so I must thank you for joining us this afternoon, and in particular I must thank our panel, Richard, Michelle and Richard, for joining us this afternoon, and I hope you found their advice useful, their hints and tips useful, and that you will be able to go away, encourage your members of staff to engage with what you offer and to form and build good learning and development habits. Thanks, everybody. Do join us for future sessions in our compliance conference week. Thanks. Bye.
Bye.